session where Deborah Nelson Judge presides.
Good morning. Please be seated.
Good morning, Honor.
Good morning. We're on the record. Case number 12 CF 1083, State versus George Zimmerman. All parties are here and present. When I'm reading the jury instructions this morning, does the defense want me to include in that the right to remain silent? Okay. Was there anything else that we needed to take up before we bring the jury in?
This time we're moving to invoke the rule.
Okay. The rule of sequestration is being invoked. That means, are there any witnesses who are going to be testifying here in the courtroom? Okay. If you all want to go out and instruct your witnesses, you may do so at this time. Or
To the extent that the rule would ask the defendant's family be excluded from that rule, they are somewhat maybe witnesses either called by the state or the defense. That would include father and mother. As you know, we have not, do not suggest that the victim's family be removed from the courtroom as they are witnesses, actually more substantive witnesses, but I would think that in fairness to both families that we would allow that.
Mr.
Your
Davis.
Honor, under Rule 90.616, the only witnesses that this rule does not apply to are the parents. I would cite 90.616, the parents of the victim. Specifically in a criminal case under 90.616 subparagraph D, in a criminal case, the victim of the crime, the victim's next of kin, the parent or guardian of a minor child, or the lawful representative of such persons, unless a motion by the court determines such person's presence to be prejudicial, she'll be allowed to remain in the courtroom. And so we would respectfully request that the victim's parents be allowed to be remain in the courtroom. We would object to anybody else being in the courtroom that's going to potentially be a witness.
Familiar with the rule, Your Honor. However, this court does have the discretion to allow other members of the defendant's family as well. And though the state has listed them as the witnesses and may well intend to call them, they shouldn't, by that maneuver, be allowed to exclude the defendant's family from the courtroom.
Well, they may come in after the state is finished with their case. Is there a reason why you feel that they need to be here in disregard of the rule of sequestration?
Yes. They are supporting their son in a second-degree murder charge and have the right to be here both for their own purposes.
Show me a case that says that, please.
Not prepared right now because this wasn't addressed at pre-trial, Your Honor. So I would like some time to do that. Maybe while opening statements are ongoing, we'll get that for you. To the extent that that's going to occur, do you want them out at this point?
Yes.
Then Mr. Crump will also leave the courtroom?
Is he listed as a witness?
Yes, he is, Your Honor.
Yes, he will.
And any other witness you can identify.
Are there any other witnesses?
If that's the state's position, then the defendant's family should not be here.
Our position is we would just like the rule to be followed, and we've cited the rule.
Okay, and the rule says the victim's family. Everybody else must leave the courtroom until further notice of the court.
Also, Mr. Crump qualifies as the legal representative of the victim's family, so he should be allowed to remain in the courtroom.
No, Your Honor, he's a very substantive witness in this case, and they have full representation here with the mother and the father. Should not extend this to a substantive witness.
I would point out, Your Honor, that as the court is well aware, Mr. Crump has been the subject of many motions. Throughout the proceedings, he has been available. In fact, last week he was available. The defense made a decision not to depose him at this time for tactical reasons or whatever, but which they have the right to do. But if it was such an urgent matter, they made a decision not to depose him.
Not certain of the relevance of that argument to the 616 exclusion of a witness that the state seems to be, again, still moving to enforce. I would, again, suggest a relaxation of it, but if the state does not want to go there and wants to follow the letter of it, I think that we should. And I would note that 616 is in the alternative. Either the victim's family or legal representative, it does not say and. The intent of that is to allow for Mr. Martin's family to have representation, and they do. Mr. Crump, however, is going to be a very significant potential witness in this case. And if it's not going to be relaxed, it shouldn't be relaxed.
Okay, the rule specifically states in a criminal case, the victim of the crime, the victim's next of kin, the parent or guardian of a minor child, or a lawful representative of such person, unless upon motion the court determines such person's presence to be prejudicial. So the state is asking for the rule to be invoked, or you asked for the rule to be invoked. The state asked for the rule to be invoked, and they're asking that Trayvon Martin's family or parents be allowed to remain, which is provided for, and they're asking for Mr. Crump to remain under what portion?
Under that same statute, Your Honor.
A representative?
Yes, Your Honor.
Okay.
He is the legal representative of Mr. Martin, the deceased.
And at this time, I don't have anything in this rule or any case law that says, of course, Mr. Zimmerman's family that's not on a witness list may sit throughout the trial. The issue is on the witness list.
If I might, Your Honor.
Yes, you might.
The 616 was never intended to suggest that the legal representative could be a substantive witness. The intent was to be certain that the victim's family under this statute is represented. They are well represented by mother and father. It was never an intent, and I would think it would be an absurd intent, and I'm about to file an oral motion to clear this up, that a substantive witness in the case would be able to slide in under the suggestion of a legal representation. So let me say it this way. I hereby move orally that it is prejudicial to allow a
Tell
substantive...
me the prejudice.
I'm about to, if I might. The prejudice is that Mr. Crump has continually committed or had press conferences where he has evidenced a strong representation, not only legally, but factually. It was 25 minutes ago that Mr. Crump had a press conference where he said there are only 2 facts that matter in this case to the public. I won't recite them to the court in case you didn't see it, but he very, very focused, suggesting his position factually, not just as a legal representative for this case. So as a factual witness, one, let's not forget, whom the Fifth District Court said is so substantive and has so few protections that we can take his deposition, is going to be a factual witness. He is a witness.
I don't recall them using the words that it's so substantive. I recall them saying, and I'm characterizing, that the deposition is extremely limited and should not take very long to accomplish.
Nonetheless, I don't want to argue with the point of what the Fifth District said. I understand your position. However, we have the right to depose him. That would, in my opinion, suggest that he is, in fact, a substantive witness. If he was
And
ministerial...
when did the 50CA opinion come out that told you you had the right to depose him?
A month
ago, and you
Yeah.
haven't deposed him yet.
And I think the court is well aware why.
Well,
If need be, I will tell you what I've done for the past 30 days, getting ready for this case to try today. But the reality is, the fact that we've decided to wait until this week to take his deposition does not suggest that he's less than substantive, does not suggest that he's a legal representative that should slide under 9616 when the family is otherwise fully represented.
the court made note last week when you had brought up about the depots that Mr. Crump had sat in this courtroom the entire time of jury selection, and that he was here and available, and you could have used the court reporter and this courtroom to accomplish that deposition any evening or at any time. So it was not his availability. But I don't want to get into that right now. I'm going to ask Mr. Crump and the defendant's family that are under subpoena to please leave the courtroom. We will get the case law over lunch, and the court will review the case law and make a final decision. I'd like to get on with closing arguments, and that's why I'm asking that to be done at this time. I don't know, I see that Mr. Crump is here. I don't know if there's any member of Mr. Zimmerman's family that's here that's under subpoena. Okay, if they are, please inform your witnesses that the rule of sequestration has been invoked. Anything else we need to take up before we bring the jury in to start with instructions? Yes, sir.
Police Court, I did this morning file a motion due to the fact that came up during the deposition on Saturday over the weekend. It simply relates to, apparently there is a
a exhibit prepared by a witness who was provided for deposition on Saturday. That exhibit is, as far as I know, still yet unviewed. But if there's going to be no mention of it in opening statement, obviously the state is fine with deferring consideration of the motion for you. If there's going to be a mention of this, and it's specifically witness Shoemaker and a recreation, then I think we would prefer to have that addressed now.
Well, I just walked on the bench, and it's sitting up there. I have not looked at it. It has not been provided to me before now. Mr. O'Mara, were you intending to mention this in opening statement?
The animation itself, Your Honor, not specifically, but I will tell you that there is a demonstrative evidence aside from that which the state has been provided, not the animation, but literally what we call a poster, which is a scene, you might call it a snapshot from the animation. So,
Is there any objection to that demonstrative?
I would like to see it first.
Which
we'll tell them which one it is. We sent them all 10, but I'll point out which one.
Could you please do so now, because we're getting ready to go into opening statements. Thank you. Okay. There's no objection to that? Okay, that's great. Anything else? Who's going to be doing the opening for the state?
No, I will.
Mr. Guy, and for the defense? Mr. West. Okay, thank you.
We do have another matter, though. We touched on it last Friday. It has to do with the raised gestate statements. There was some question precisely what they were. I had raised the issue back in late May when we had the hearing on the state's sort of generic motion to exclude hearsay of the defendant. And has the court received the motion?
I received something that's on my desk, but I was working on the Fry hearing order. So at the time that I received it, I was right in the middle of doing that. So I have not read it.
Well, Your Honor, I have a copy that the court may have now, of course. This is very important evidence, and that the court, I think... Can I ask
you, sorry to interrupt, but can I ask you, are you going to be mentioning any of that in opening?
Yes.
Well, then we need to have a hearing on this. Let me have the motion.
Thank you, Judge. This is an unsigned copy.
That's fine. Thank you, Susan.
We request a copy of the motion.
Another copy?
None was given.
The state was not given a motion, the copy of the motion?
When was it
We
provided?
have document that it went on Friday, but I'll get you the copy.
We have not received any motion.
Okay.
I know you spoke about it Friday, you're right, but...
This is unsigned.
Sure, that's fine.
Okay, has the state read the motion?
We have none.
Okay, is the state familiar with 90.8031?
Yes, Your Honor.
Okay, and the defense is also? Because there are a couple of statements here, and two of which I find would fall within that, the third of which may not. I don't know how much time expired between the event and the police officer arriving, and I would have to know what that time frame was. Is there any response by the state as to those three statements?
Regarding, to answer the court's question first, it was within minutes of the shooting in terms of when the officer responded and also when he made statements to, at least one of the statements alleged to witness number 13, whose name will become known. I will point out that witness number 13 in his deposition, when he was asked regarding the statements, he stated that the defendant was calm. So I don't know that it rises to the level of excited utterance. He did make those statements.
Well, it says a spontaneous statement describing or explaining an event or condition made while the declarant was perceiving the event or condition or immediately thereafter, except when such statement is made under circumstances that indicate its lack of trustworthiness. If more than a slight lapse of time has occurred between the event and the statement, the spontaneity is lacking. The statements to witness 13, I think, would fall within that. I don't know as to the law enforcement officer, so I will reserve as to that one, but the other two.
I can help with the timing. It was very, very fast. As the motion indicates, Officer Smith was already en route because Mr. Zimmerman had told the dispatcher to please send an officer. So he was always there. I think it's less than a minute, and he, witness 13, and Mr. Zimmerman were standing there when Officer Smith walked right up to them. So, in fact, Officer Smith said at his deposition that Mr. Zimmerman spontaneously said, "I was yelling for help and no one would help." So it's very close in time. It's not a question really of the actual number of seconds in any event. It's really the circumstances, and the trustworthiness comes from the circumstances themselves, not a precise measure of the time, keeping in mind that Mr. Zimmerman was bleeding from the face and from the back of his head. He was out of breath and had been staggering, and witness 13 described him as someone who had just gotten his butt beat. Within seconds of that encounter, Officer Smith came up, and Mr. Zimmerman was handcuffed for the officer's safety and said,
Okay.
I was...
I
have the Stiles case, which quotes extensively from the Alexander case. Both of those cases were cited by the state in its original motion in limine, but they are squarely on point with my issue here.
Okay. What I'm reading here is that while there is no requirement under the spontaneous statement exception that the statement be made while the declarant is in an excited state, in order for a section 90.8032 exception to be present, the declarant must be excited. Under section 90.8031, spontaneity and contemporaneity are key rather than an excited state of mind, so I will let them in. Any other matters that...
One final
Yes.
housekeeping matter. I just wanted to introduce to the court Sarah Waldrop. She's a trial paralegal and will be assisting us throughout the case.
Thank you very much.
Not been in court.
And welcome. Anything else we have to do to... We're ready for the jury. Let's go ahead and bring them in. Oh, I know. If counsel would please approach for one brief moment. Welcome back, and I'll be with you in just one moment. Okay, be with you in just one moment. As the rules of sequestration have been invoked, that means to any potential witnesses that they're not to listen to any portion of the trial, whether they be at home or here at the courthouse, that they're not to discuss their testimony that they will be giving during this trial to anybody other than the attorneys if they request a meeting for them. They're not to allow anybody to tell them what is going on during the course of the trial. And I hope, good morning, ladies and gentlemen, and I hope that you're all well settled in, and I welcome you back to court. Before we get started today, I'm going to ask you certain questions, and if your answer is yes to any of my questions, please raise your hand. During the recess overnight, did any of you read or listen to any radio, television, or newspaper reports about the case? No hands are being raised. Did any of you use any type of an electronic device to get on the internet to do any independent research about the case, people, places, things, or events? No hands are being raised. Did any of you have any conversations with each other or with anybody else about this case? No hands are being raised. And finally, did any of you read or create any emails, text messages, Twitters, tweets, blogs, or social networking pages about the case? Okay. You were previously sworn, you were selected and sworn as the jury to try the case of the state of Florida versus George Zimmerman. This is a criminal case, and George Zimmerman is charged with murder in the second degree. The definition of the elements of the crime charged will be explained to you later. It is your solemn responsibility to determine if the state of Florida has proved its accusations beyond a reasonable doubt against George Zimmerman. Your verdict must be based solely on the evidence or lack of evidence and the law that I will give you. The information, which is the charging document that I read to you on Thursday, is not evidence, and you are not to consider it as proof of guilt. It is the judge's responsibility to decide which laws apply to this case and to explain those laws to you. It is your responsibility to decide what the facts of the case may be and to apply the law to the facts as you find them. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it would be helpful if you understood how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys an opportunity to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the attorneys will have an opportunity to make their final argument. Following the arguments by the attorneys, the court will instruct you on the law that is applicable to this case. After the instructions are given, you will then retire to consider your verdict. You should not form any fixed or definite opinion on the merits of the case until you have heard all of the evidence, the argument of the lawyers, and the instruction on the law that I will give you. Until that time, you should not discuss the case among yourselves. During the course of the trial, when we take recesses, and you will be separated from the courtroom and go about the sequestration rules. And during these recesses, you will not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about the case, tell them that you are on the jury and trying the case, and ask them to stop. If they persist, leave them at once and immediately report it to one of the court deputies. The case must be tried by you only on the evidence presented during the trial in your presence, in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation on their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in the case. This applies whether you are in the courthouse, during your sequestration, or anywhere else. You must not visit any of the places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors must not have any discussions of any sort with friends or family members about the case or the people and places involved. So do not let even the closest family members make comments to you or ask you questions about the trial. In this age of electronic communication, I want to stress this again, that just as you may not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections that they deem proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you don't want to. That will be left up to you individually. You have been provided with a notepad and a pen for your use if you wish to take notes. Any notes you take will be for your personal use. However, you should not take them with you from the courtroom. During recesses, the deputy will take possession of your notes and will return them to you when we reconvene. After you have completed with your deliberations, the deputy will deliver your notes to me. They will be destroyed. No one will ever read your notes. If you take notes, don't get so involved in the note-taking process that you become distracted from the proceedings. Your notes should only be used as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence.